What you know, Alibis. Welcome to another episode of Pretty Lies and Alibis. I'm Gigi. Good to have you here. It's Thursday, March 13th. Big correction from yesterday. Somebody pointed out on the episode about the missing University of Pittsburgh student in the Dominican Republic. Several times I said Mexico instead of the Dominican Republic. And the reason is I was Googling vacation spots in Mexico for an hour before I did that episode. And clearly it was still on my mind. So if you hear me say Mexico in your mind, think she meant Dominican Republic. Clearly, your girl needs a vacation. Also, yesterday, I was going to do my weekly Patreon live with my members there. Normally, I set those to unlisted, and that way it's just the Patreon group in those. And I was distracted when I was setting up the feed and made it to public. And I didn't know until about 5 minutes in. It ended up being really fun and a good mistake. It was a reminder I need to do more lives with everybody too. So if you missed that, you can go under the live tab on my YouTube channel and watch. We talked about a lot of different cases, and it ended with me talking about how much of an Oregon Trail nerd I am and how I got to go on the actual Oregon Trail in Boise last year. We have some filings in the cases that we're covering, and we're going to start off with Lori Vallow Daybell. She filed a motion in limine to preclude expert testimony of Daniel Coons. The filing says Daniel Coons was on scene the day Charles was shot. I spent some time this morning going through the documents from the Chandler Police Department about Charles's shooting. I saw that Detective Coons was present when Alex Cox came back to the house later the day Charles was shot to do a walkthrough with investigators, and Daniel Coons was also present at Charles's autopsy. Let's read her filing. And the first section is facts. The state filed a supplemental notice of disclosure to the defense 4 weeks before trial, noticing retired Daniel Coons as a firearms expert. Previously retired Daniel Coons was listed as Detective Daniel Coons of the Chandler Police Department and not an expert. Not is in all caps and underlined. It's the understanding of the defense that Detective Coons was the scene agent on July 11th, 2019, the day of the alleged crime. Now, 4 weeks before trial, the defense is being notified that Detective Coons will not be testifying as a scene agent, but rather as a firearms expert to give his opinion. The word opinion is underlined. A CV attesting to the expert's qualifications has not been made available to the defense, nor has a defense interview occurred. For over a year, Detective Coons has been listed as a witness and not an expert. Noticing an expert allows the defense the opportunity to recruit a rebuttal expert. However, the absurdity of the timing of the disclosure of this detective, now turned expert, violates due process. This is not a sufficient notice to even 1. Locate an expert, 2. Request funding approved by OPDS, 3. Have our expert perform their own analysis, 4. Complete a report, and 5. Prepare and testify at trial. The defense believes this is a tactic used by the state to prevent defense from offering a rebuttal expert. Federal Rules of Evidence says in part, the use of the term expert in the rule does not mean that a jury should actually be informed that a qualifying witness is testifying as an expert. Indeed, there is much to be said for a practice that prohibits the use of the term expert by both parties and the court at trial. Such a practice ensures that trial courts do not inadvertently put their stamps of authority on a witness's opinion and protects the jury from being overwhelmed by the so-called expert. The defense concludes this detective, who has been listed as a witness for over a year, is now being identified as an expert and has been inserted by the state for the purpose of giving his opinion under the false banner of expert at the last minute before trial. The defense requests that retired Detective Daniel Coons be precluded from offering any expert testimony at trial, since it's a violation of the due process rights of the defendant. That was all for that filing. I'll keep an eye out for the state's response and a ruling by the judge. Moving on to Donna Adelson, a few updates on some depositions. Sigfredo Garcia was scheduled to have given a deposition on March 10th, and Donna's team is taking a deposition from Wendi Adelson on March 21st. That's going to be done remotely with Wendi in Austin, Texas. Also, Katie Magbanois is set for hers on April 3rd. Y'all, I give anything to be a fly on the wall for Wendi's deposition. There's a new filing in Donna's case. It's a motion in limine regarding the court file from the dissolution of marriage. It says the state has listed as Exhibit 60 a divorce filing indicating their intent to admit the entire court file in Adelson versus Markell. By this motion, Mrs. Adelson moves to exclude and or limit State's Exhibit 60. First section is discussion. Although Florida statutes permits a party to ask a court to take judicial notice of court files, the contents of the court file and the documents contained therein must still be admissible. The contents must be relevant. Additionally, documents which contain hearsay are still admissible. In Stoll versus State, the court held that although a trial court may take judicial notice of court records, it does not follow that this provision permits the wholesale admission of all hearsay documents contained within those records. We have never held that such otherwise inadmissible documents are automatically admissible just because they were included in judicially noticed court files. To the contrary, we find that documents contained in a court file, even if that entire court file is judicially noted, are still subject to the same rules of evidence to which all evidence must adhere. The divorce file contains over 560 pages. It's significant that Mrs. Adelson was not a party to the divorce proceedings. There can be no credible argument that the vast majority of documents have any relevance to this proceeding by way of example, summons, notices of unavailability, motions and requests for production, notices of filing deposition, transcripts, orders directing mediation, notices of mediation, mediator reports, notices of hearing, notices of subpoena, affidavits of service, Leon County Clerk receipts, report of dissolution of marriage, motions to reduce time to respond to notices of production, resignation and order terminating parenting coordinator, designations of email addresses, motions and order for substitution of counsel. The only significance the undersigned can fathom is the state desires to use the size of the divorce file to support their false narrative that the divorce was a bitter custody battle. Those documents which make up the majority of the exhibit do not survive a relevance analysis in any way. In seeking admission of the divorce file in previous trials, the state has asserted the statements contained in certain filings go to motive of the defendant then on trial. Namely, Mr. Markell's March 26, 2014 counter motion for enforcement of MSA on parenting issues and motion for contempt and sanctions, and his various filings. They list several dates in 2013 and 2014 that Dan Markell filed these. Although an argument could overcome the relevancy issue addressed above, the state must still establish their admissibility as either an exception to hearsay or as non-hearsay. Regardless, the state of mind exception to the hearsay rule does not extend to the admission of the divorce file in its entirety. Significantly, the state of mind of the declarant is the subject of the exception in Florida statutes, and it applies solely to the declarant's state of mind rather than the state of mind of the defendant. For example, in Bailey versus State, the defendant's first-degree murder conviction was remanded for a new trial because hearsay statements of the deceased victim, which tended to establish a motive for the alleged crime, were obviously offered to prove the state of mind or motive of the defendant, a purpose for which the hearsay exception created by Florida statutes does not apply. With respect to Mr. Markel's March 26, 2014 counter motion for enforcement, the motion contains 8 specific requests. Only one of these requests applied to Mrs. Adelson. Namely, the motion identifies statements allegedly made by Mrs. Adelson to or in the presence of her 3 and 4-year-old grandchildren. Her 3 and 4-year-old grandchildren later allegedly repeated those statements to Mr. Markel. The state has previously referred to this 16-page motion, not including exhibits, as the mother-in-law motion. A little over 1 page of this 16-page document, plus the prayer for relief, concern Mrs. Adelson. There is no relevance to the remaining pages of this motion. Even if any of the remaining issues are relevant, they do not survive Florida statutes balancing, as their probative value is substantially outweighed by the danger of unfair prejudice, confusion of issues, or misleading the jury. Statements reportedly made by Mrs. Adelson are admissions. However, statements made by her grandsons to Mr. Markel are hearsay. The statements in Mr. Markel's court filings are also hearsay. Florida statutes require the proponent of statement to assert valid exceptions for each level of hearsay to render the statement admissible. With respect to the alleged statements repeated by the 3 and 4-year-old grandchildren to Mr. Markel, and which Mr. Markel placed in the court file, there are 2 levels of hearsay the state must overcome for the documents to be admissible. Even if there is an exception for one level of hearsay, there is no exception for the second level of hearsay. In Nowak versus State, the court reversed the defendant's second-degree murder conviction where the trial court permitted a detective to testify to what a co-defendant said the defendant stated about shooting the victim. The court recognized that what the defendant said to the co-defendant was an admission. However, there was no valid hearsay exception to allow the detective to testify to what the co-defendant said to the detective. The state has previously argued that Mr. Markel's statements in the court file were not hearsay pursuant to Florida statutes because they are not being admitted for the truth of the matter asserted, but rather go to the defendant's motive. Simply stated, the statements go to the state of mind of the listener. In such circumstances, statements by Mr. Markel in his counter motion and other filings would not be hearsay to establish Mrs. Adelson's state of mind. If the state can even establish Mrs. Adelson knew the statements had even been made. They cite Blackwood versus State, which says victim statements to the defendant were relevant to establish the defendant's motive. They also cite Eugene versus State, where a victim's emails to the defendant were relevant to demonstrate the email's impact on the defendant. Absent evidence establishing Mrs. Adelson was aware of Mr. Markel's March 26, 2014 counter motion, the state cannot admit that motion as evidence in Mrs. Adelson's trial. Donna Adelson respectfully requests that this honorable court grant this motion in limine, enter an order excluding and or limiting admission of the court file from Adelson versus Markel, and for such further relief as is just and proper. Moving on to Bryan Kohberger. There was a state's response to a motion in limine excluding IgG evidence, that is the investigative genetic genealogy. And it does give us a sneak peek into the defense strategy regarding that knife sheath that had Bryan Kohberger's DNA on it. Instead of challenging the conclusion that the DNA on the knife sheath belonged to the defendant, the defense's expert disclosures reveal that the defense plans to argue the DNA on the knife sheath does not prove the defendant was ever at the crime scene, and the knife sheath itself could have been planted by the real perpetrator. So there you go. It looks like they're going to claim he was framed for these killings. The state doesn't plan to refer to the IGG evidence, but will instead tell jurors that a tip led them to Kohberger as a suspect of the killings. In another unsealed filing, we find out the defense wants to leave out certain words: murder, murderer, murdered, murder weapon, psychopath, sociopath, and references to bushy eyebrows. In the filing, the defense said to label Mr. Kohberger as a murderer, the alleged weapon consistent with an empty sheath as a murder weapon, or to assert that any of the four decedents were murdered by Mr. Kohberger, denies his right to a fair trial and to the right to be presumed innocent. They're also asking the court to limit the number of crime scene photos shown to the jury. In another filing, they asked that his purchases from Amazon as well as his click activity be left out, saying it could be unfairly prejudicial. And it also says that Amazon's algorithm suggests products to users. On the flip side, the state is asking the defense to not refer to them seeking the death penalty as an attempt to kill Mr. Kohberger. His next hearing is set for April. That is it for today. I hope you guys have a good rest of your afternoon, and we will see you soon.